Good afternoon. It's about 1 o'clock, and so if you're here for the webinar, you're at the right place. My name is Wendy Murray, and I'm with Precedent Hospitality. We provide management services to condominiums, HOAs, and co-ops. We always enjoy partnering with Good to Boast and Cross Law Firm on educational webinars. We consider them an industry leader, and we always learn something. So whether you're a client or not, we're glad you're here today, glad you're willing to learn. And if you learn at least one thing today, we would have considered the webinar successful. I'm pleased to be here today with Leanne. And Leanne, you want to tell us about your law firm and you?
Yeah, good afternoon, everyone. Thank you, Wendy and President, for hosting us today. I'm Leanne Bosch. I'm a partner and shareholder with Godey DeBost and Cross. We are a full-service law firm, most well-known, I believe, in this area for practicing condominium and homeowners association law, in addition to cooperative associations. Okay, are we ready to get started, Wendy? Any other opening comments?
I would just add that we're going to try to take some questions throughout, but we do want to stay on time because we respect your time. Our goal is to be able to complete the whole presentation. So the majority of the questions will be saved to the end, and a PowerPoint of the presentation will be available to attendees. Those are the things I would want to add, just because those would be our first questions.
That's right. Okay, so this course is called Understanding the Association's Governing Documents and Tools for Compliance and Enforcement. Like Wendy said, we are expecting to be here about an hour, so we will make some time for questions as well. I've got about 40 slides to present. If you do have questions, please put them in the Q&A box at the bottom of your Zoom platform. I cannot unmute anyone to ask a question, but if you put your question in there, we'll try to address it either as we go or have some time at the end for questions. Based on our experience presenting these, we typically get more questions than we are able to answer during the presentation. So if we don't get to your question, I'm sorry. Please reach out to us. Feel free to email us with your question. We'll try to get back to you. And if we don't, we will sometimes use your questions for article questions in our newspaper column. So please pop your question in the Q&A box. And again, feel free to email us if we don't get to it. And like Wendy said, we will make the presentation available for you as well. I will share the presentation with Wendy too. You can contact Wendy or contact us and we will give you a copy of the PowerPoint. I'm going to pop our contact information up on the screen for just a second for anyone who wants to take it down. As I mentioned, feel free to contact us if we don't get to your question. We have our email address here and our website and our phone number. And this is also going to be at the end of the presentation for anyone that misses it. Okay, so our agenda today is, first we're going to learn about the association's governing documents. Generally, that's going to include your declaration, articles of incorporation, bylaws, and then the rules and regulations. After that, we're going to jump into enforcement. So first we'll discuss what the documents are, then how do we enforce them when owners, tenants, guests, and others do not comply with them. So we're going to discuss in detail some of the enforcement tools that you have available to you. We will discuss suspensions, fining, self-help, and then finally, if our standard remedies don't work, dispute resolution and potentially legal action. Because we are attorneys, we first have to offer a disclaimer. So please know that the information in these slides and this presentation is not legal advice and should not be considered legal advice. Our presentation presents our personal opinions of me and Wendy. If you have any specific questions regarding your community or your governing documents, you need to consult with the association's attorney. That is not something we can give you legal advice on today. Our presentation is for informational and educational purposes only. Okay, so let's jump in. First, I want to discuss the hierarchy of the association's governing documents. And this hierarchy is relatively important because it governs which document controls over another. At the top of your hierarchy, whether you are a condominium or a homeowners association or a cooperative association, condominiums, you're going to have something called a declaration of condominium. That is at the top of your hierarchy of governing documents. If you're an HOA or a co-op, you're going to have a declaration of covenants or a declaration of restrictions, or it might be called a declaration of easements. That is your longest governing document. It's at the top. It's going to control over all of these other governing documents that you see below it. So if any of these other documents conflict with the declaration is going to control every time. So right below that, we have the Articles of Incorporation, and we're going to talk about these in detail. Below that, we have the bylaws. And below that, we have rules and regulations and board policies and architectural guidelines, things of that nature. These are things that the board has adopted. You may have heard, and I know, Wendy, you probably heard this too, I hear it all the time, the use of the word bylaws as a generic term to just describe the rules of the association. So, you might hear someone say, well, our bylaws say you can't park in the street. Well, they actually don't, because you're probably referring to the declaration or the rules and the regulations, not the bylaws. But just know that that word bylaws, it refers to a very specific governing document of your association. And most of the time it doesn't have the use restrictions in it. But that's something that it's sort of used as a misnomer and is not used correctly. So most of the time when you're looking at use restrictions like street parking, you're going to be referring to your declaration or your rules and regulations. So what about Florida statutes? I haven't included that here. We are trying to focus on the association's governing documents, but I'll make a couple of notes here. Florida law is at the top of all of this, right? But Florida law doesn't always prevail. Sometimes Florida law prevails, sometimes it doesn't. Generally, procedural issues in the statutes, for example, you have to post your notice of board meeting 48 hours in advance, are going to prevail. That would be a procedural issue in the statute. Those are generally going to control of your governing documents. So if your governing documents say you only need 24-hour notice of a board meeting, you're probably going to have to abide by the statute, which requires 48 hours. Substantive issues, on the other hand, prevail depending on the way that your governing documents are written. And you might have heard of Kaufman language. Kaufman language is language in your governing documents that contemplates the inclusion of the statute and as it is amended from time to time. So, documents that are absent of Kaufman language might be stuck being governed by the 2003 version of the Condominium Act or the Homeowners Association Act, whereas documents that do contain Kaufman language are incorporating changes to those statutes as they are made from time to time. So we'll always be abiding by the latest version of the statute. That is a very high-level review. It involves a very complicated legal analysis, whether the statute controls on substantive issues versus your documents. So that's something that you should consult the association's attorney on. But I wanted to raise that because, sometimes the documents conflict with Florida law. Again, talk to your association's attorney if you have any questions about which one's going to control. But as it relates to the declaration, articles, bylaws, and rules, this is the hierarchy. If the articles conflict with the declaration is going to control. If the bylaws conflict with articles of the declaration articles are going to control, and so on. And your rules and regulations are really right at the bottom of the food chain. Those cannot conflict with anything. Okay, we're going to talk about those in a bit more detail. Okay, so let's discuss the declaration. Like I said, right at the top of the hierarchy, it is controlling. This is your longest document, tends to be, 30, 40 pages. It is going to be upheld by the court unless it is invalid for some reason or it violates public policy. The courts have said that these declarations of covenants are clothed with a strong presumption of validity. That means they're going to be enforced even if they have something that's a little strange or crazy in there. So anytime the association wants to incorporate a new use restriction, the best place for that is going to be in the declaration. That is your most enforceable document. as opposed to putting it in the rules or regulations. Some things are better in the rules and regulations and some things are better in the declaration, but just know that this document is going to control over everything and is upheld by courts. You know, there's not a whole lot of legal challenges that someone could raise to challenge a restriction that's in your declaration. So the declaration establishes a lot of use restrictions, rules, and obligations of property owners in the community, including, you know, maintenance, enforcement, and they run with the land, which means that they're attached to the property. So if you buy a home in a homeowners association and you have never seen their declaration of covenants, you didn't know it existed, you're still subject to it. You are on notice. It is being recorded, it is attached to the property, and it is enforceable. So prospective purchasers are on notice regardless if they knew it existed or they've ever seen it before. Okay, so what about the Articles of Incorporation? You probably know that your community is operated by a corporate entity. So all of your communities will have a corporate entity that the board is operating under, you know, Sunny Lane Community Association, Inc., for example. Without the Articles of Incorporation, the association would not exist. The Articles of Incorporation legally create that not-for-profit corporate entity that operates the community. They define the corporate structure. That would include the name of the community or the corporate entity, its principal officers, its initial board of directors. And the articles also provide legal authority to that entity to enter into contracts, to sue and be sued, to own property, to enforce rules and regulations. And they often will also establish voting rights and membership rules. This is the shortest document in your set of governing documents. This is usually only about 5 pages, and we don't often have to look at it, but sometimes we do know that it exists. It is in there. Probably the one you're going to use the least, but it is important because it, again, establishes that entity that operates your community. Okay, let's move on to the bylaws. Again, this is the word that we just hear the most commonly used to describe all the documents, but this document has its own function and it is separate from those other documents that I discussed. The bylaws are longer than the articles, shorter than the declaration. They generally are going to describe the roles and powers and duties of the board, the officers, and any committees that you have. They govern meetings, so how meetings are called, whether it be a board meeting or a membership meeting, what type of notice is required for those meetings, what type of quorum is required to have those meetings, whether we can use proxies, and then what voting rights are. You know, how are votes cast if the unit is held by a married couple or by an entity or by a trust? The bylaws typically address those things. And a lot of the times they also authorize rulemaking and enforcement, and we're going to discuss rulemaking authority in a second. But if you're ever looking for, you know, the board's authority to establish rules and regulations, you can typically go to the bylaws and find a paragraph on the board's rulemaking authority. Okay, so here are the rules and regulations. Like I said, at the bottom of the food chain, all those other documents we just discussed are recorded in the public records of the county where the property is located. The rules and regulations are generally not recorded. There was a period of time for I think a couple of years or so where the statute required rules and regulations to be recorded in HOAs. So we have a bunch of HOAs who have recorded some of their rules and regulations, but the statute was changed. I think that was really a mistake by the legislature. Rules and regulations are not required to be recorded in the public records, and most of the time they are not. So all those other documents, we can find them if we go look for them in the county's public records. The rules and regulations, you generally have to request a copy from the association. So rules and regulations and nestled under here are also board policies, board forms, conduct policies, architectural guidelines. These are any things that are established by the board as opposed to a vote of the membership. These are things that the board can adopt supplemental to those other governing documents. But The first part of this is to understand what the board's rulemaking authority is. How broad is it? So again, most of the time we find that in the bylaws. Sometimes the rules and regulation, sometimes the bylaws will say that the board can adopt rules and regulations governing the common areas. Sometimes it says governing the common areas and the units. So it's important to understand what rulemaking authority you have, because if your declaration says you can only govern the common areas, then the board should not be adopting any rules and regulations that govern the use of the lots or the units. Okay, so the rules and regulations again are adopted by the board pursuant to rulemaking authority granted by the governing documents. They supplement the broader provisions of the other governing documents. There is more flexibility with rules and regulations because they can be changed easily at a board meeting with a board vote, whereas those other documents generally are going to require advance notice to the members, and the members are going to be entitled to vote on them. Rules and regulations, again, a lot easier to change, so there's some flexibility there. They generally govern more minor day-to-day kind of things like pool rules and garbage rules, what your property looks like, what are acceptable paint colors, things that might change from time to time. So how do we adopt enforceable rules and regulations? First, there must be authority to adopt them. And that was that authority I was describing in the bylaws. You need to go look at your association's declaration. It's usually going to be either in the declaration or the bylaws or both. What is your rulemaking authority? Secondly, rules are required to be reasonable. This means they must be rationally related to a legitimate objective of the association, and they cannot be arbitrary or capricious. The rules also must not conflict with any of the other governing documents, and they must be clear and consistently enforced. So that is how you adopt an enforceable rule or regulation. And we're going to discuss this a little bit more, but as I mentioned, the strongest place for your restrictions to be is going to be in your declaration. The rules are more easily subject to challenge because they have all these requirements to be reasonable. Number one, declaration, there's no requirement for it to be reasonable, right? It is clothed with a strong presumption of validity. The rules, on the other hand, a court needs to decide that the rule that you've adopted is reasonable. It can't conflict with the others. It has to be clearly drafted. And again, rationally related to a legitimate objective. So you can see that rules tend to be more easily challenged than the other documents like the declaration. Okay, let's talk about amending the association's governing documents. So as I mentioned, the declaration, articles, and bylaws, they are amended with a membership vote in almost all cases. There are some exceptions, but most of the time we require a membership vote. And they are amended in accordance with the procedures that are detailed in there. And those thresholds to amend them, the membership vote that you require are not necessarily the same for all of them. So you have to look at the declaration, scroll to the amendment section, it's typically right at the end, and it will tell you how to amend that document. Same with the articles. Articles typically have their own amendment section, and same with the bylaws. The most modern amendment thresholds that we see are 2/3 of a majority that show up and vote. The older ones tend to be, a majority of everyone, not just those that show up a vote. Sometimes we see, 80% of everyone, which is very high and hard to achieve. The threshold I typically recommend, again, is 2/3 or a majority of those who show up and vote. This allows us to sort of disregard anyone who is not participating. So if you haven't cast a vote and you couldn't bother to show up to the meeting, we're not going to count you, but we are going to count those who show up. And we're going to require 2/3 or a majority of that group of people. Okay, so just briefly regarding, how we amend these governing documents. We can either amend them on a piecemeal basis, which means we're amending, one or more sections, just those sections, and we're adopting a separate amendment that we will attach to the existing declaration, articles, or bylaws. And it makes it somewhat difficult to read. It's, some underlining and striking through to show where we've added language or removed language. But that's a very common way to amend documents. The second way is to do a full restatement. We just rewrite all of them. Generally recommend amending at least every 10 years or so. The law does change, makes it easier to uh, understand the governing documents, avoid conflicts between the statute and the documents. So generally recommend putting that on your radar for at least every 10 years or so. But as you move along, if the leasing section is not working for the association anymore, you can do a piecemeal amendment there and amend just the leasing section. That's perfectly fine. And these amendments generally almost always require to be recorded in the public records. So you can find them and prospective purchasers can find them, unlike the rules and regulations. Okay, so what about amendments to the rules and regs? So we mentioned that these are adopted by the board. They are also amended by the board. So they can be amended by majority vote at a board meeting where there is a quorum present. As we know, we need 48 hours notice of our board meeting. There is an exception here. Florida law provides that if you are going to be amending rules and regulations regarding parcel use or unit use if you're in a condominium, that requires a heightened notice period. So it's 14 days mailed and posted notice. It is still a board meeting, but it requires a greater notice period, that 14 days versus the 48 hours. So keep that in mind. But if you are just adopting a rule regarding your pool, for example, the pool hours or maybe use of the playground, that does not impact parcel use or unit use. Those are common areas, right? Or common elements of your condominium. So that would just be a 48-hour notice. The only time this heightened notice period comes into play is when we are trying to regulate the parcel or the unit itself, and the board is adopting rules in that regard. Again, you want to make sure that you actually have that authority. Check your documents to make sure that you can adopt rules regarding the parcels and the units. Okay,
We have
so
a, we
yeah, go
have a
ahead.
question, Leanne. Someone
Mhm.
is asking where in the governing documents would they see the Kaufman language?
That's a great question. It's usually throughout the governing documents. A lot of the times I will see it in the articles. There might be a definition in the declaration that might define the Condominium Act or the Homeowners Association Act, and it will say, as it is amended through this date, being the date of recording, or as it is amended from time to time. And sometimes you might see it in separate sections. So you might see it um, as amended through this date in section 5, and then in section 7 regarding collections, you might see it referring to the Condo Act as it's amended from time to time. So it's not always the entire document. Sometimes there are separate sections incorporating Kaufman language and not. So again, not an easy analysis, but I recommend having an attorney review the documents. Again, I usually see it in the definition section in the declaration, and then also under, the powers section of the articles or the bylaws. And you have to really thoroughly review all the documents to determine whether it applies and where it applies, whether it's everything or just certain sections. Good question. Thank you. Okay, so that's, what the association's governing documents are. So what about when owners or tenants or guests are not complying with the governing documents? What enforcement tools do we have available? So let's jump into discussing enforcement of the governing documents. So these are the recommended first steps for enforcement. I want to mention here that this is not required by law. There is no statute saying that you have to first send a friendly reminder or you first have to send a violation letter to let the owner know that they're in violation. Technically, you could just go straight to fining. You notice a violation, you fine the owner, or you suspend their right to use the pool, or you could do that. That is not a good practice, but I'm just letting you know that there's no statute that says that you have to first, do this. So it can be a good idea to establish a compliance policy for your association. I'm going to let Wendy chime in on that because I know she recommends that to her clients. This will be a policy that will help you enforce the governing documents uniformly, avoid selective enforcement, and kind of what do we do first when we first notice a violation? What is our next step? And for most associations, that would be sending a friendly reminder or a warning letter, and then, maybe a violation letter threatening to escalate the matter, send it to legal or fine. But what do you recommend regarding compliance policies, Wendy?
Thank you. What we recommend to our associations is they adopt a very clear, simple policy. It gives the manager direction for doing the enforcement, and it makes sure that there's no selective enforcement, that one owner doesn't get more time to cure their violation than another owner. For example, the compliance policy that we suggest is one that maybe states, what is the first notice of violation? Is it a friendly reminder? Is it an email? Is it a letter? What is the method for the first notice? And how many days are they given to cure the violation? And then the second letter, how is that notice sent? And how many days are given for them to cure the violation? And if they do like the 3-strike rule and the third notice is the final notice, what do you want in the letter? Some associations want a photo. They like to insert a photo in that third and final letter. They want it sent certified mail. So defining that and defining the cure period helps the manager or violation inspector, whoever's doing the enforcement. It gives them direction from the board as to the compliance, the cure period for the violations, the method of noticing, and it just helps to make sure that one owner is not treated differently than another. That's usually what we recommend. And that way we don't have to keep going back to the board and we don't have to keep asking, okay, do you want us to give them 10 days or 14 days? It's very defined and it keeps us on track to treat everyone the same way.
Yeah, that's great. And I think it's a great idea. And I think the key word for the compliance policy is simple and clear. Um, the reason why is because, as I mentioned, this policy is not required by Florida law. You don't have to do any of this, but it does help the association stay out of trouble and avoid selective enforcement. But it's self-imposed. So you're self-imposing these regulations on yourself. Okay, we're going to send, the first warning letter and it's going to be sent by, certified mail or whatever. We're going to enclose the picture. If you make that too convoluted, it will be used as an opportunity for owners to try to set aside fines or suspensions. In my experience, when the policy is very complicated and convoluted, um, the association is going to mess it up, right? Because it's just too difficult to follow. And that's going to open the door for challenges to fines or suspensions. The owner is going to say, well, my fine is not valid because you didn't follow step, 17 in your enforcement policy. So just keep that in mind. I also like to allow a little bit of flexibility with the compliance policies, because violations are not all the same. Some of them are more of an emergency than others. If someone's painted something the wrong color, and we can give them 14 days, that's no problem. But if someone has got something that's dangerous or hazardous in their property, that might require more immediate action. So we try to put a little bit of flexibility in those policies where we can. Okay, so what if our friendly reminder or our violation letter doesn't work? What do we do next? So we have a lot of tools in the enforcement toolbox. I know associations focus on fining a lot, but the fining is really just one tool in that toolbox of enforcement options. So fining, obviously, we can issue monetary fines against owners, tenants, guests for failing to comply with the association's documents. We'll discuss that in more detail. We can also suspend their right to use the amenities. We can suspend their voting rights. We'll discuss that. Many communities also have what we call self-help available to them. You have to look at your governing documents, talk to your association's attorney before you engage in this. But what it is essentially entering the property and taking whatever action is necessary to cure the violation or in the case of a condominium, entering the condominium unit and doing the work. And oftentimes being able to lien for the cost of the work. So, you give the owner the opportunity. If they still fail, you can go in and do the work. Good example is, a green pool in an HOA. The owner, maybe the property's abandoned, the owner doesn't care, doesn't have the money, and the pool has become a health hazard. The association might have the option to enter, do the work, and lien for the cost of the work. Keep in mind, there may be violations where you can leverage code enforcement. So again, depending on what it is, but if it's especially something relating to real property, sometimes a violation of our covenants is also a violation of county code. So sometimes we can just report a violation to code enforcement and have them do the work for us, and they will seek enforcement. So keep that in mind. It has been helpful for me in my practice for some of my clients. Not for every case, but some of them. And then finally, if we tried everything we can, we've tried all these typical remedies, we might have to escalate the violation to the legal team, where you may be required to go to arbitration before you go to court, or potentially mediation before you go to court. I want to mention one more thing about self-help. Clients love to hear about this remedy, but in my mind, it is not always a good remedy. It is good for abandoned properties. But if you have an occupied property, and especially where the owner might be aggressive, has threatened the association, that's generally not going to be a property that we are going to want to enter and do anything with, because it just isn't worth anyone's safety. So just keep that in mind. Again, good for abandoned properties, maybe some other situations, but isn't as good as it sounds.
We have
Okay,
a
so
question
yeah.
on grandfathering. When you grandfather someone in, is that considered selective enforcement?
So there's actually there's Florida case law that discusses grandfathering, and that process typically comes about when the association has failed to enforce a certain provision for a long time. And there's a process that we can use, and really it just involves a board meeting, adopting a special resolution at a board meeting that says, essentially, we know we haven't enforced in the past, but we are going to enforce moving forward. So in order to do that, to implement that process, we generally have to grandfather existing violations. So that's where we see grandfathering. So it kind of draws a line in the sand and says, everything else, we know we can't enforce it, we fail to enforce, but you're all on notice now that from this date forward, we are going to enforce. So it actually gets you out of a selective enforcement defense if you do that. So if you haven't enforced for a long time and you're facing claims of selective enforcement, that's how you get out of it, is you grandfather, all the existing violations, and then you draw that line in the sand and say, we're going to strictly enforce moving forward. So that's a good question. And keep in mind, the grandfathering is only until the end of the useful life of, whatever it is. So if we're grandfathering, I don't know, patio extensions, we haven't enforced and we want to start enforcing. The patio extension is grandfathered until the end of its useful life, not forever. So it cannot be replaced again, but we're going to grandfather it, until it needs to be replaced, or until it gets damaged and has to be removed, etc. Good question. Okay, so what can we suspend? How do suspensions work? We can suspend voting rights for delinquency, only for delinquency. We can suspend amenity use rights for delinquency and for violations. Let's discuss those a little bit more here. In my experience, by the way, suspending voting rights a lot of times doesn't do anything, but it's good to know you can do that. It helps in small condominiums if someone's holding up a membership vote. Okay, so suspension of voting rights for delinquency in an HOA has to be more than 90 days delinquent. In a condo, it has to be more than $1,000 and more than 90 days delinquent. In a condo, you also have to provide 30 days notice of the delinquency before the suspension takes effect. And then at least 90 days before an election, you have to notify that owner that their voting rights may be suspended due to non-payment of a fee or other monetary obligation. No hearing is required here, which is not the same for fining and not the same for suspensions based on violations. So voting rights suspensions based on delinquency, no hearing required. Here are the steps. We give proof to the owner of the delinquency. That's for condos only, at least 30 days before. Then we need a board meeting to approve the suspension, and then we need to notify the owner by mail or hand delivery that their voting rights have been suspended. The suspension is going to end upon full payment of all obligations. What is the impact of suspending someone's voting rights? Here's what the statutes say. You have to subtract that voting right from the total number of voting interests. It is not going to be considered for any purpose, including establishing a quorum. So it's as if that property does not exist. You now have a lower total number of owners. All right, what about suspending amenities based on delinquency? If an owner is more than 90 days delinquent in paying any fee, fine, or other monetary obligation, the association may suspend the right of the owner to use common elements, common areas, facilities, or any other association property until that monetary obligation has been paid in full. Okay, condos and HOAs, both of you have similar language in the statute that says that you cannot suspend certain areas. So we cannot suspend someone from using their elevator to get up to their unit. They always need to be able to access the property, right? But we can suspend their use of the pool or the pickleball court. We can also, again, a lot of my clients will use this to make it more difficult to gain access, but we cannot stop access. So associations will make owners use the guest entrance at the front gate. That one usually gets payment pretty quickly. So you make an owner go through the guest portion of the gate and suspend their barcode for the easy access lane. Sometimes we get payment pretty quick when we do that. There is a bit of an enforcement issue regarding who's going to stand at the pool and make sure that Mr. Jones doesn't use the pool. That part can be a little bit hard, but just know that you can suspend these things. The statutes also prevent us from suspending utilities. So question we get a lot is, is cable and internet a utility? Can we suspend cable? The statute doesn't define utility. I suspect that cable and internet are not utilities. However, I think in our modern world, those services are becoming more and more of a necessity for emergency information. I generally advise clients against suspending cable or internet. And I also find that, we have to fight with the cable company to suspend cable anyway. That's not necessarily an easy process. So I generally advise clients against suspending those things. And again, for this, a suspension of amenities for delinquency, no hearing required here. Okay, suspension of amenities for violations. Statutes say the association can suspend for a reasonable period of time the owner's right to use the common areas, common facilities, etc. Remember that same language carved out where there are areas that we cannot suspend. This one does require a hearing, and we're going to go over the hearing process in a second here. 14 days notice of a hearing before this can take effect, and the committee does have to approve it before you can implement the amenity suspension. Keep in mind also the law requires that you suspend for a reasonable period of time. So you have to use some common sense here. It's not forever. We can't say, well, you haven't power washed your roof, so you can no longer use the pool forever. That's not going to fly. We have to use discretion based on whatever the violation is. Okay, so fining, who can be fined? You may be surprised to know it's more than just the owner. It's, the occupant of the unit, a licensee, someone they invited onto the property, their family members, their guests, etc. Okay, couple of differences here between fining in a condo versus an HOA. Both statutes say we can fine $100 per violation per day or $1,000 in the aggregate for a continuing violation. Condos, you are stuck with that language. HOAs, you do have the option to amend your governing documents to provide for higher fining authority. The fines still need to be reasonable, but you can overcome that statutory default. So some associations will increase the $1,000 to $5,000, for example. And this is especially helpful for short-term leasing, for example, where we really need to hit the owner in the pocket to get the behavior to stop. And then what about that $1,000 cap and, reference to a continuing violation? When does that cap come into play? So the example I use is street parking. If an owner parks their vehicle in the street and leaves it there for 15 days, that is a continuing violation, and that is where your cap is going to kick in. That $1,000 cap is going to kick in, and you're going to be stuck at the $1,000. The violation is continuing from day to day versus the owner putting the vehicle in the street on Monday, taking it away on Tuesday, bringing it back on Thursday, etc. Every time they move it and bring it back, that's a new violation where we can fine $100. And the cap is not in play. That is not a continuing violation. So keep in mind that difference. In condos, fines can not ever result in a lien on a unit. In HOAs, if your fine is $1,000 or more, we can lien the unit for that fine. Again, in both cases here for fining, a hearing is required. We have to give the owner due process before we impose the fine. So what is due process? The law says due process is fair treatment according to established rules and principles. In the fining and suspension context, it's going to involve an open board meeting to levy the fine. We're going to give notice to the owner that the fine has been levied, and then the owner is going to have the opportunity to appear before a panel of impartial owners, kind of like a jury, which we call a committee, and they're going to have an opportunity to present their side of the case. And then the fine cannot be imposed unless the committee approves it. Please know that not following this process is going to cause your fine to fail. So if you've given them 13 days notice of the hearing, and you bring that to your attorney and say, well, we did give them notice, here it is. Well, it's 14 days, so we can't enforce that fine. You have to follow it properly. And if the owner requests to reschedule the hearing, says, I'm not going to be available on that day, I strongly recommend rescheduling the hearing. I have had a fine fail in court because an association refused to reschedule the hearing when the owner, wasn't convenient for the owner. So make sure you follow this. It's very important if you intend to enforce that fine. Okay, so here's what it looks like on our little diagram. We have a right violation. We're going to, again, before this all starts, we're first going to try some warning letters, right? But we're going to have a right violation. We're going to have our board vote. Then we're going to notify the owner that they were fined, give them 14 days notice of a hearing. Then we're going to have our hearing, and then we're going to send a post-hearing notice letting them know what happened at the hearing, whether the committee approved or did not approve. So real quick regarding appointment of the committee is appointed by the board. Both statutes say that these people that serve on this committee cannot be board members. They cannot reside in a board member's household. There have to be at least 3 of them. They also cannot be officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. So the goal here is obvious, right? We want an impartial committee. These people cannot be tied to the board. They have to be impartial. And if the committee does not approve the fine or suspension, it cannot be imposed. So keep that in mind when you're appointing your committee, that you're appointing people who are going to be in favor of enforcing the governing documents. Practice tip, if you can, appoint more than 3 committee members to allow for substitutions. I know Wendy and I were talking earlier about, one of the fine committee members having to decide a fine for their neighbor, for example. This could be a good option where that person just doesn't serve on the committee that day. Put someone else on there. Keep in mind that the committee cannot change the fine or suspension. The committee's role is really limited to approving or rejecting it. So they can't say, well, $700 is a bit high, but we'll approve a $400 fine. It doesn't work like that. They either need to approve the $700 or reject the $700. There are some special rules here for HOAs. If you're a 720 HOA, here are some new statutes that came into effect last year. Within 7 days after your hearing, the committee is supposed to provide a written notice of their findings relating to the violation, including any applicable fines or suspensions that they approved or rejected, and how the owner may cure the violation or fulfill the suspension, and the date by which the fine must be paid. The statute now allows 30 days for payment of fine in an HOA. Previously, it was 5 days. Condos, you still have 5 days. And here's the real kicker here in HOAs. The statute now says if a violation has been cured before the hearing or in the manner specified in the hearing notice or committee finding notice, the fine or suspension may not be imposed. So you might go through this whole process, have your board meeting, schedule your fine hearing, and then the owner cures the violation. And let's say the violation is that they left the trash can at the bottom of the driveway, and then they pull it back up. Well, now it's being cured, and you've gone through all of this, and now the statute says that we can no longer fine. This statute is very problematic. I don't know what the legislature intended here, but I think that there may be some arguments to get around it. Talk to your association's attorney. Potentially there are some violations that we consider to not be curable because the violation has already has already occurred, and we cannot cure it. So know that this exists, and if you're not sure whether you can enforce your fine or not because the owner has cured before the hearing, I recommend speaking to the association's attorney. A couple of other special rules in HOAs, Chapter 720, you cannot levy a fine or propose or impose a suspension for any of these two things. The first one is leaving garbage receptacles at the curb within 24 hours before or after the designated collection time. So as long as the owner has not put it out more than 24 hours in advance and has collected it within 24 hours of pickup, we cannot fine or suspend. Doesn't matter what your rules say. So it doesn't say we can't enforce in other ways. It just says we cannot fine or suspend for those things. So keep that in mind. And then second exception here is relating to holiday decorations and lights. We cannot fine or suspend unless we first sent them a 1-week demand saying, you have a week to remove these things, and otherwise we're going to fine or suspend. You have to first have sent that notice. All right, so a couple of commonly asked questions here regarding the committee. Can the owner who appears before the committee bring a witness or their attorney to the hearing? My position is yes. Again, we're trying to provide due process to this owner. If you have to enforce that fine in court, we want to be able to show the judge that the owner had a fair opportunity to defend themselves. I think the attorney should be allowed to attend. I do like to require advance notice. So if the owner's bringing their attorney, the association should have an opportunity to have their attorney present as well. Must the association provide the owner with the right to speak at the hearing? Absolutely. Owners should be given ample opportunity to present whatever arguments they have, whatever evidence they have. If they want to call witnesses, they want to bring pictures. The owner doesn't control the meeting, but they have the right to speak for a reasonable period of time. So make sure that you provide that. Again, that is very important for that due process requirement that we need for enforcement. So is it the committee's role to justify or defend the board's decision? No, it's not. That's the board's job, right? So the board has levied the fine. Maybe the manager will handle the meeting or the board will handle the meeting, but the board will present the association side of the case, and then the owner will present their side of the case. And then the committee's decision is to listen to everything from an impartial position and decide whether to approve or reject. They are supposed to be separate from the board and have different interests to the board. Okay, may the committee ask questions? Yes, absolutely. The committee's job is to determine whether this fine or suspension should be imposed or not. So if they don't have all the information, they can absolutely ask questions. Does the committee need to deliberate, decide, or advise the owner of its decision at the hearing, or can the association notify them after the hearing? This very much depends on the association's governing documents and how they address committee meetings. If the committee hearing is supposed to be, by the documents, required to be open, just like board meetings, then it's my position that deliberations need to be open, whether it's going to be at the original hearing or maybe they adjourn and then, reopen the hearing at a later date. That's fine too. So check governing documents here, check with the association's attorney. Okay, so what if fining, suspension, and all these other remedies we discussed, what if they don't work? What do we do next? So this may be a time when, the association considers escalating the violation to the legal team. know that certain disputes are required to go to arbitration or mediation for condos, or if you're in an HOA, mediations, before they ever go to court. So this provides sort of an alternate dispute resolution process before we are suing someone. In condos, we used to be forced to go to arbitration. Thankfully, we now have the option of offering mediation, which is more favorable in my opinion. Okay, so I have some slides about, what is a dispute under the requirements of the statute. So if you are in a condominium or a co-op, a dispute that needs to go to a pre-suit proceeding involves the authority of the board under Florida law or the documents to require any owner to take any action or not to take any action involving their unit, or to alter or add common areas or common elements. So for example, if the owner has installed pink hurricane shutters and we don't allow pink hurricane shutters, that's a dispute that is going to be required to go to arbitration or mediation before we sue the owner. Also, any disputes that involve the failure of a governing body to properly conduct elections, this would be the association, give adequate notice of meetings, properly conduct meetings, or allow inspection of books and records. These are all things that, again, have to go to arbitration or mediation before they go to court. In addition to the statute telling us what is a dispute, it also tells us what is not a dispute. So this list of things includes things that they say, this is not a dispute, you can go straight to court, we don't need this to go to arbitration or mediation. So title to a unit or a common element, levying fees or assessments, collection of assessments, removal of tenants, breaches of fiduciary duty, and then claims for damages to a unit based on failure of the association to maintain the common elements or the condominium property. So again, if you determine that you're in a condo co-op and those, your dispute involves those things, before litigation, you have to initiate non-binding arbitration with the DBPR, or you have to offer pre-suit mediation. DBPR proceeding is similar to a court proceeding. It's a little bit less formal, takes a very long time. Mediation, on the other hand, is a form of alternate dispute resolution where there's a neutral third-party mediator that tries to help the parties come to an agreement but doesn't make any decisions. It's voluntary, it's non-binding, it's confidential. We can usually get it done in a day or half a day. That is generally more favorable remedy, but it depends on what your dispute is, whether you decide to go to non-binding arbitration or pre-suit mediation, something you would discuss with your attorney depending on the association's goals. There is an exception here: election and recall disputes not eligible for mediation. Keep that in mind. All right, and again, if your disagreement is not a dispute under the statute, you can initiate legal action right away. There are some arbitration decisions available online. I've given you the link. They're not binding, but they are persuasive and give us an idea of how the DBPR generally rules on certain issues, so they can be helpful. What about in HOAs? When do you have to offer pre-suit mediation? Again, we don't have arbitration in HOAs, just mediation. These are the things that the statute says require us to go to mediation before we file a lawsuit. So use over changes to parcel of common areas, covenant enforcement disputes, amendments to the association's governing documents, meetings of the boards and committees, membership meetings, and access to official records. The process of offering pre-suit mediation to an owner can be a very useful remedy, and has proven to be useful in my practice. So if you have a stubborn owner that has a stubborn violation and fining has not worked, suspension has not worked, you can't engage code enforcement, you're out of options at that point. Your next step could be to serve a demand for pre-suit mediation on the owner. It gives the owner two options. They have 20 days to respond. They're either going to agree to mediate, and if they do, they have to split the mediator's fees, or they are not going to respond. And if they do not respond, they are going to waive their right to recover attorney's fees in court, even if they prevail in court. So if we sue them and they win, they cannot recover their attorney's fees. So it forces them to engage in some way. They're either going to agree to mediate, or they're not going to agree, or they're not going to respond, and they're going to waive very meaningful legal rights that they have in court. So when we are at the end of the rope with enforcement and we have just not been able to get an owner to comply, this can often be a very useful tool as a next step. And is certainly much cheaper than litigation, is often required before litigation. So keep this remedy in mind if you, again, are at the end of your rope with enforcement. Okay, that is the end of my presentation. We will have a look at the Q&A box. Wendy, is there anything that's outstanding? Otherwise, I'm gonna just take a quick look at it. We have about 5 minutes or so for Q&A.
There are a lot of questions in Q&A, but one that jumps out to me that may benefit the most people is someone asked about MRTA and about the expiration of their governing documents. Can you just touch on that a little bit?
Yes, I can give you a high level review of that. So, but you have to ask your association's counsel. Generally, previously older law stated that after 30 years, if you're in an HOA, your covenants could expire right after the 30-year time frame. We now have new provisions in the law that allow us to, preserve them as we go along. But check with the association's attorney whether you're subject to that. Condos, you're not subject to that. Your declaration could be, from the 60s. It's not going to expire. Older declarations and HOAs might be subject to expiration, and there may be action that you need to take before that 30-day time frame kicks in. Okay, so someone's asked about, our rules and regulations governing documents. Am I correct that they're not governing documents? I think they are governing documents. And I think I just tend to use governing documents very broadly. It's any document that, governs the community. And I think rules and regulations do that. So I consider them to be part of the governing documents. Now they're different to the declaration, articles, and bylaws, but I still think that they are a part of the association's governing documents.
If an association wants to cure the violation, the question is, what steps are necessary?
So depending on if you're a condo HOA and you're getting that authority from the statute or your documents, the steps that are typically required, again, this is fact specific. You have to look at your documents, talk to your attorney, but generally we are required to provide notice before we do that. And that part's very important. You haven't cured the violation. Per section 7 of the declaration, we are going to be entering your property to do the work if you have not done it within 10 days of the date of this letter. And that's typically, all that's involved is a notice process. They need to know when you're coming, what you're going to do, and then you would go in and do the work. And then, of course, hopefully have the ability to lien the property for the cost of that work. Can we download the presentation? We will definitely make the slides are available. So please contact my office or contact Wendy and we can give you a copy of the presentation. So this is a good question regarding amendments to the governing documents. Before you spend the money to do a full restatement, do you recommend doing a separate resolution lowering the majority of voters required to pass the amendment? Oftentimes, when the governing documents have a very high amendment threshold, that is what we do. So especially with developer documents, the older ones, the amendment threshold is as high as, 75 or 80% of the entire membership. And especially where you have a community that's a bit more complacent and doesn't participate as much, that can be almost impossible. So, before you dive into a big full restatement project where you're not sure if it's going to pass or not, that can be a good first step, is to just piecemeal amend that amendment section to lower it and try to get that one pushed through. And then once it's lowered, we're in a better position to know that our full restatement is going to pass.
There is a question, someone's HOA was started in 1988, and it doesn't say anything in the governing documents about fining. Can they still fine under 720?
Good question. So that is going to involve that complicated legal analysis that I discussed earlier regarding Kaufman language. Can you utilize the statute or not? If you have Kaufman language in your declaration and the statute, I don't know what the 1988 statute provided regarding fining, but it's going to depend on the interplay between your governing documents and the statute.
We've had a lot of good questions today.
Very good questions. I think maybe time for one more. I'm looking through the Q&A, see what we can answer here that might answer a few of them at one time. Unfortunately, not going to be able to look at all of these. I'm not going to be able to send the slides to anyone individually. Please contact us for the slides. I'm getting some requests to send the slides individually. Will not be able to do that, unfortunately. Okay, question, do you need a vote of the owners to do a restatement of the governing documents? Not to take on the project. So to take on the project, generally the documents will provide that the board can do that. So, who can propose an amendment? Usually it's the board. Sometimes it also allows the owners to propose amendments, but in my experience, most of the times, it will allow the board to propose the amendment. The board will work with the legal team or maybe a committee to prepare the documents. And then the part where the membership vote comes in is when we're actually approving them. So, we propose it and then the membership either votes to approve it or reject it. Okay, I think we are out of time. Thank you very much, everyone, for your participation. These are really good questions. I'm sorry that we're not able to get to all of them. Hope the presentation was helpful. Thank you, Wendy. Thank you, President, very much. And I know that we will be back with more webinars like this one.
Thank you so much.
Bye-bye.